Thanks so much for being with us here on Atlanta News First Plus. I'm Joy Lim Nakrin. Just want to share with you a couple of the top legal stories that we are following today. And I want to introduce a special guest that's joining us, attorney Josh Schiffer, with us, who is based out of the Atlanta area. But one of the major stories that we have been following here on Atlanta News First Plus, Fulton County officials have seated a grand jury which is expected to decide whether to actually hand up an indictment against the former president, Donald Trump, and some other well-known political and legal figures for alleged interference in the 2020 presidential election. It's something that we've been following very closely here. Okay, so Josh, you know, the significance of the grand jury being seated here, we all know the saying, you could indict a ham sandwich. But why is this important, though?
Absolutely. This is really important because it's a sacred process. We all hear about due process when we're taking our civics classes when we're younger. This is what we really mean. What are the steps involved that the state has to take in order to efficiently and effectively complete their mission, their mandate, as set forth by voters? So in this case, the district attorney of Fulton County, the Honorable Fani Willis, she has been elected. She's a brand new first-term elected DA here in Atlanta, replacing her longtime boss, Paul Howard, under whom these investigations might have begun. Ms. Willis has now been in the chair for a couple of years and has spent an enormous amount of time and attention on the Donald Trump issue, the election issue, because she is the elected district attorney in the county in Georgia that has our capital. And that means that the vast majority of political cases are going to be handled through the Fulton County court system, and that's indeed what she's focused on right now.
Yeah.
Sorry.
I'm sorry, Josh, go ahead.
To remind everybody, this is the famous phone call, the Find the Votes case. And what happened is, after the election, after the investigation, it became very clear that there was probable cause that some crimes might have been committed. Therefore, Fani Willis used a special grand jury that she convened using the permission of the court to specifically gather a unique grand jury with only one task, and that was to investigate the various issues involved in this phone call and potential other allegations involving the theft or delay or manipulation of the Georgia election results. And what that resulted in is a multi-month investigation, all performed in secret with the assistance of the DA's office, wherein that special grand jury released a report earlier this year. That report has been sealed. In fact, there was a lot of commotion when the report was finished because the public wanted that. But Judge McBurney, in ruling on motions to release that report, declined to release that report. It remains secret. And that was in order to allow other jurisdictions to continue other cases involving the former president. At the meantime, Fani Willis has an obligation to move forward with whatever she's going to do with this report. And that's what we're all waiting on. This week was important because this is the term of court within which she has promised to take action on the special grand jury report involving the alleged theft or manipulation of Georgia's election results. Fani Willis convened two grand juries. In Fulton County, we have a Monday-Tuesday grand jury, and we have a Thursday-Friday grand jury. Grand juries are going to have a minimum of 16 people in order for it to be an effective grand jury, but only 12 people are required in order to return an indictment or a true bill on indictment. That true bill indictment is the formal charging document that will then be presented to the defendant as well as the court and eventually the jury. That's the law the jury is going to be required to consider in determining whether a law was broken. So this sounds all really complex, but I promise it makes sense when you step back and look at the entire situation. Where we are right now, what's going to happen right now, very, very little. We're going to sit back with very little information as Fani Willis presents her report to the grand jury, and that grand jury will return an indictment sometime within the next 30 to 60 days. The good news being that Georgia has pretty strict laws when it comes to releasing the results of a grand jury. So when and if the grand jury does return any indictments, we will know about them relatively quickly. What happens at that point? Who knows? Georgia's a very different jurisdiction than New York. It's a very different jurisdiction than Florida. And these being state charges in a major urban center, they're going to have practices and policies that probably differ substantially. In fact, I'm going to tell you they do because I go there, than New York and Miami when it comes to how individual defendants are treated. And I know a lot of people are interested to see if former President Trump is going to be granted the same grace and permissiveness in the system of checking in, being arraigned, being processed, as the local jails here in Fulton County are well known to be a challenge. They're very difficult, and it can be difficult to operate in and around our legal system due to the size and the lack of resources.
Josh, can you explain the difference between these grand juries that have now been selected as compared to the special purpose grand jury? How do they differ, and why is the distinction important?
So a grand jury, a regular grand jury, is convened by a district attorney in every jurisdiction when it comes time to bring about charges that have been approved using the grand jury indictment process as required by law in Georgia. There are charges that the DA cannot directly accuse that require an indictment. An indictment is a formal charging document. You are entitled as a defendant to a charging document that is perfect in form, as with substance. So there can't be any mistakes on an indictment. You've got to very specifically list enough or sufficient facts to indicate what violation of the law is believed to have happened, and enough facts surrounding that to allow a defendant to identify the charge as well as defend against it. We had a long time where indictments were insufficient, not enough words were included in order to set up a defense. That's been changed, and I guarantee that Fani Willis is following the book explicitly with these Donald Trump-related cases, because she knows that the first line of defense for anyone wrapped up is going to be a thorough review of the documents and resulting appeals. The big difference between the two grand juries is the regular grand jury meets and handles all cases that are presented to the grand jury by the DA. They are oftentimes kind of thought as a rubber stamp, like you talked about, Joy. You can really indict anybody for pretty much anything, because it's a one-sided unilateral process. The state shows up, they are represented by a DA who tells the court or tells the grand jury what they feel happened, and doesn't ask about guilt or innocence. They ask whether there's been probable cause established to continue the investigation and the case by producing a true bill of indictment. That true bill of indictment accuses an individual specifically of violating specific laws under a specific context, and is basically a request for the state to prosecute them. That's different from the special grand jury. Special grand juries have a limited scope, a limited work product power, where they can only go in and investigate certain issues. However, they have a lot of power with those investigations. Their end product was a report, the secret grand jury report. That report is then used by the district attorney's office and the new independent regular grand jury to determine what charges and against whom this process is going to move forward.
And, I'm just reading a quotation from Judge McBurney here, who says, you're at least, to the jury, you're at least a check to make sure that folks aren't being brought into court for a trial simply because that's what the district attorney or the attorney general wants. It's what the people have affirmed through the true bill of the indictment. So it's another kind of layer of justice, kind of maybe another check. And it seems to be important in this case because there have been, assertions, accusations that this whole prosecution would be politically motivated, right?
Absolutely. And one of the most important things to remember is the indictment process is that check in the check and balances of state power. Back in the olden days, whatever the king said went, whatever the despot said went, whatever the dictator said went by inserting and requiring 12 citizens, 12 people whose names can be known, whose work is recorded in public with some good transparency. By requiring that, it prevents the state from using the bully pulpit to just punish people randomly, arbitrarily. This prevents the state from picking people up from the community and wrongfully accusing them, because the state, in order to achieve a true bill, must present enough evidence to satisfy the probable cause requirement for indictment and the issuance of a true bill of indictment. And that's not guilt beyond a reasonable doubt. It's not even preponderance of the evidence. It is a low standard, but there is evidence, there must be evidence sufficient for a grand juror to conclude that a crime more likely has been committed and that it deserves prosecution and investigation.
I also want to just take a moment to point our viewers to our website, atlantanewsfirst.com, because this is where you can actually see the full transcript of the phone call and hear the audio of that phone call that then President Trump, had with Brad Raffensperger. So, it's something that, of course, has been really a focal point of the investigation. And you may just want to listen for yourself, with the Georgia Secretary of State essentially saying, suggesting that perhaps Raffensperger could help him, quote, find 11,780 votes, just enough needed to beat Joe Biden. So check that out on AtlantaNewsFirst.com if you want to listen to it and read the transcript. Sorry, Josh, you were going to say something?
Oh, no, I just wanted to add, that's where this case begins. And it's a fascinating beginning because the evidence was right out in front of everybody, basically, as it happened. This was a giant news story and clearly has been covered by everybody since then. But what it really was is it opened the door to the investigation then performed by the Fulton County District Attorney's Office, other law enforcement agencies. That investigation has now consumed and kind of eaten up through osmosis other investigations. The investigation broadened. Now it includes literally dozens and dozens of potential targets, ranging from our political leaders of the highest caliber all the way through local electors, individual citizens. We have a class of alleged fake or phony electors, as some people like to call them, who were summoned to the Capitol in order to vote on an alternate slate of electors. There were a lot of questions about how that process took place. There were issues involving representation of the electors and whether there were conflicts in who could defend them, because individual defendants shouldn't be sharing the same lawyer because of the inherent conflict in the lawyer's duties to those individual defendants. So this investigation expanded. We don't know the level of cooperation with District Attorney Bragg in New York or Jack Smith's case down in Florida through D.C. This case continues to aggregate, get bigger, get more complex, and we'll see very soon how the Fulton County District Attorney Fani Willis is going to approach arguably the most complicated trial of her career.
Yeah, absolutely. Thanks so much, Josh, for your analysis there and really taking us into the process. Okay, I want to get to another story that our viewers have been following. We've been sharing with you, our viewers, about the South Fulton mayor, Khalid Kamau, returning to the office just days after being arrested. He actually led last night's city council meeting, and this was the mayor's first public appearance since he was released from jail on Saturday. Despite facing some felony charges of burglary and trespassing, he is really not giving many answers to the city and the residents. There are calls for him to resign. His next court appearance is scheduled for September. Josh, what's your take on all of this?
This is wild and woolly, and the one thing I can guarantee is we don't know the whole story. So first of all, let's talk about South Fulton County. While it has been part of Fulton County, obviously, for decades and decades, the establishment of the city of South Fulton County is relatively new. And in fact, this is a brand new set of governing individuals who don't necessarily get along very well. There have been extensive issues involving personality and work clashes between the city commissioners and the mayor, as well as law enforcement. The mayor is a very progressive, some would call a bleeding edge progressive, a self-described Christian democratic socialist. He was found on an individual's land next to a lake by the individual who owns the land. He was, according to him, looking at his dream property and looking at a wonderful house that he was interested in making a financial play for. That differs extensively from the report of the homeowner, who indicates that he saw a person he didn't know on his security cameras, showed up at the location, and that's where really the differences start. The homeowner makes allegations stating that the mayor was inappropriate with him, aggressive, did some grandstanding, some of the "don't you know who I am" kind of conversation, whereas the mayor indicates that the homeowner was overly aggressive, used a sidearm to hold him at bay. There might even be the possibility of crimes being committed against the mayor. But at the end of the day, the mayor faced 2 charges, one of which is relatively minor, and the mayor has basically admitted that since this incident. He was criminally trespassing on the gentleman's land because he didn't have prior permission to be there, and that's criminal trespass. The bigger problem is the felony burglary. Burglary in Georgia is statutorily defined and requires an intent to commit a felony as well as being inside or on the property of another. It's that intent to commit a felony that's going to be the big issue with the prosecution of the mayor, because so far no one has alluded specifically to what kind of felony was involved, and that original charge is now being potentially called bad faith, brought in bad faith by law enforcement, because there are struggles between the local law enforcement community and the mayor relating back to statements made by the mayor, as well as some financial decisions made by the city council involving law enforcement compensation. So there are already cries that this is some home cooking or some dirty dealing, and we don't have the full story of what happened.
Yeah, and I'm just pulling up the story on our website, AtlantaNewsFirst.com, if folks want to read a little bit more about it and look at our coverage. It's this South Fulton, this new city of South Fulton, riddled with many issues that we've been covering, that we've been investigating, as you said, and this is just kind of another twist and turn in this fairly new city. So lot to follow, and we're going to keep track of all that, Josh. Another case that we have been following very closely is the Young Thug trial, and just in this latest development, and by the way, I mean, this is a historically long jury selection process that's still underway, right? I mean, here we are in July. It's been going on since the start of the year.
Still underway, the longest jury selection in Georgia ever, and it is shocking because we don't know when it's going to end.
And so then, now, here's the newest thing, which is, another drama, right? The judge, Glanville, has found a potential juror, and again, these are potential jurors. I mean, it's a jury selection process. A potential juror has been now found in contempt for not showing up when she was supposed to, and now is going to be required to attend the first 5 days of the trial or else go to jail for 20 days. What do you know about this? What do you think about this?
Well, Judge Glanville is a very firm judge when it comes to an orderly courtroom. Many people don't know this. Judge Glanville is one of the most high-ranking military judges and lawyers in our military currently. He has been very proud of his military service for decades, and he's also a deeply respected trial judge on the Superior Court of Fulton County. It's kind of why he ended up with what has become the most complicated, long case basically in Georgia history. The setting for the YSL trial is that the district attorney, Fonnie Willis, is using a powerful tool of RICO, the Racketeering Corrupt Organization Law, here in Georgia, to attempt to tie together multiple members of the Young Slime Life crew, gang, or recording label, depending on who you want to trust most, And by tying together all of these individual acts with the individual alleged perpetrators, the district attorney's office is trying to use the aggravated sentencing and other law enforcement powers available under the RICO law. When you have a RICO case, the RICO case is by its very nature doubly complicated than a regular case because there's 2 or more people. In this case, we got up to almost 30 individuals charged with a variety of different actions that stretched back years and years. The district attorney's office believes that all of these individual independent incidents are actually linked into a crime family unit organization or gang called YSL, and they were all done in furtherance of each other. And this includes murders. This includes huge, major criminal cases of which people have already been prosecuted and convicted for. By tying these all together, Fonnie Willis is attempting to basically lock up the alleged leaders of this group away for life. So the fight is huge. Because of the number of people, there were many lawyers necessary, an independent lawyer for each and every client. That included some public defenders who at one point complained that they weren't being paid enough. And it's added just the regular complications that you have when trying to select a jury out of the community when there were so many stakeholders involved. That process has taken now 7 months, and it doesn't have any sign of ending soon. And during that, this individual juror apparently did not show up, did not participate, and was not present appropriately. So Judge Glanville used his rights and powers as an elected Superior Court judge, the power of contempt, to run his courtroom the way he feels fit. And what he has done is he has given this woman an opportunity to attend the first 5 days of the trial as a consequence for not following the court's directions. And if she fails to appear and watch the trial for the first 5 days, Judge Glanville has told her she will go to the Rice Street Jail for 20 days. And people are shocked at that, but that is in the code. It is specifically allowed. That is the methodology, tool, and mechanic that judges will use to ensure their courtroom runs smoothly. They really can call a deputy over and say, lock them up for contempt.
Wow. All right. Well, thank you so much, Josh Schiffer, joining us for analysis on several of these top stories, these cases that we've been following here on Atlanta News First and Atlanta News First Plus. So appreciate you joining us as always.
Thank you so much, Joy. It's been awesome.
Thank you.